Hello and welcome to the Minimum Competence episode for Thursday, June 5th, 2025. I'm your host for today, Andrew Leahy, a tax technology attorney from New Jersey. On today's episode, SAP's Supreme Court antitrust bid, Trump's FEC lawsuit win, and ICE's controversial plan to DNA test families facing deportation. Let's remember, history is written by the victors, but the ruins belong to everyone. And read today's legal news. On this day in legal history, June 5th, 1950, the United States Supreme Court issued its decision in Henderson v. United States, 39 U.S. 816, a significant civil rights ruling concerning racial segregation in interstate transportation. Elmer W. Henderson, an African-American passenger, had been denied equal dining services on a train operated by the Southern Railway Company under a policy that enforced segregation. Although a dining car had a partition supposedly to accommodate black passengers, in practice Henderson was often unable to access equivalent service due to timing and seat availability. The case reached the Supreme Court after the Interstate Commerce Commission failed to provide meaningful relief. In a unanimous opinion written by Justice Fred Vinson, the court held that the railway's practices violated the Interstate Commerce Act, particularly its provision requiring carriers to provide equal treatment and avoid undue prejudice. Importantly, the court based its reasoning not on constitutional grounds, such as the Equal Protection Clause of the 14th Amendment, but on statutory interpretation, finding that the carrier's conduct constituted an unjust and unreasonable discrimination. This ruling marked an early and important step toward dismantling legally sanctioned segregation in public accommodations, prefiguring later landmark decisions like Brown v. Board of Education. Although not framed as a constitutional equal protection case, Henderson nonetheless contributed to the legal groundwork of the civil rights movement and challenged the legitimacy of the separate but equal doctrine in practical terms. SAP, Europe's largest software company, has petitioned the U.S. Supreme Court to overturn a decision that revived an antitrust lawsuit brought by its competitor, Teradata. The case centers on allegations that SAP unlawfully tied its business planning applications to a required purchase of its own database software, which competes with Teradata's products. SAP argues that such software integration benefits consumers and constitutes healthy competition, not anti-competitive conduct. The lawsuit was initially filed by California-based Teradata in 2018 after the companies ended a joint venture. SAP had prevailed in the lower court, but the Ninth U.S. Circuit Court of Appeals reversed that decision in December, stating a jury should decide the case. SAP's petition criticizes the appellate court's reliance on a version of the per se rule, under which the conduct is presumed illegal without a detailed analysis. Instead, SAP advocates for applying the more nuanced rule of reason standard, which considers both competitive harms and justifications. SAP also claims the ruling conflicts with how a different federal appeals court treated a similar antitrust issue in the historic Microsoft case. The Supreme Court has not yet decided whether to hear the case. The case hinges on the concept of tying, where a company conditions the sale of one product on the purchase of another, potentially stifling competition. It's significant because whether courts apply a strict per se rule or the more flexible rule of reason can dramatically affect the outcome in such antitrust disputes. A federal judge in Washington, D.C. has dismissed a lawsuit filed by 3 Democratic Party committees accusing President Donald Trump of trying to undermine the independence of the Federal Election Commission, or FEC. U.S. District Judge Amir Ali ruled that the Democratic National Committee, the Democratic Senatorial Campaign Committee, and the Democratic Congressional Campaign Committee failed to demonstrate any, quote, concrete and imminent injury necessary to sustain a legal challenge. The lawsuit, filed in February of 2025, contested an executive order issued by Trump that aimed to increase White House control over independent federal agencies, including the FEC. The order stated that the legal views of the president and attorney general would be controlling for federal employees and prohibited them from expressing opposing positions. Democrats claimed this language threatened the FEC's independence and could deter campaign planning. Judge Ali, however, noted the administration's lawyers had assured the court that the executive order would not be used to interfere with the FEC's decision-making. He also found the plaintiffs' concerns too speculative, emphasizing that the Supreme Court requires a demonstrated change in the relationship with the agency in question, which the plaintiffs had not shown. The judge's decision hinged on the plaintiff's lack of standing, a fundamental requirement in federal court. To proceed with a lawsuit, plaintiffs must show a specific, actual, or imminent injury caused by the defendant. In this case, speculative harm and vague concerns about agency behavior were found insufficient. This principle helps prevent courts from weighing in on political disputes where no direct harm can be proven. The Trump administration is pursuing a new $25 million contract to allow U.S. Immigration and Customs Enforcement, or ICE, to conduct DNA testing on families facing deportation. The goal, according to ICE, is to verify family relationships, but critics warn the program could lead to unnecessary family separations, especially in cases involving non-biological caregivers like godparents. Civil rights advocates also raise concerns that the DNA data could be misused for unrelated criminal investigations and stored indefinitely. The contract was initially awarded in May to SNA International, a firm specializing in forensic identification. However, Bode Cellmark Forensics filed a protest with the Government Accountability Office, arguing the contract wasn't competitively bid. ICE subsequently issued a stop work order on the contract pending resolution of the protest, with a decision expected by September 2nd. This is not ICE's first attempt at rapid DNA testing. A similar program began in 2019 during Trump's first term to detect alleged fraudulent parent-child relationships, often targeting migrant families. Though handed over to Customs and Border Protection in 2021, the Biden administration ended it in 2023. Reports since then have highlighted issues with consent, with some migrants mistaking DNA swabs for COVID-19 tests or feeling coerced into participation under threat of legal consequences. Privacy advocates argue that such widespread collection of genetic data lacks transparency and oversight. The Georgetown Law Center on Privacy and Technology recently sued the Department of Homeland Security for failing to provide records on how DNA samples from migrants are collected and stored. The revived DNA testing raises some key legal questions about informed consent and the scope of data use by federal agencies. When individuals are unaware of what they're consenting to or coerced into, the practice may violate federal standards for ethical data collection, especially under the Privacy Act and due process protections. With that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, we are now officially closer to 2050 than the year 2000.